From the PEP Radio Newsroom, we have this news about a case from Alabama before the U.S. Supreme Court. The Supreme Court will hear arguments Wednesday in a case that could make it harder for convicted murderers to show their lives should be spared because they are intellectually disabled. The justices are taking up an appeal from Alabama, which wants to put to death a man who lower federal courts found is intellectually disabled and shielded from execution. The Supreme Court prohibited execution of intellectually disabled people in a landmark ruling in 2002. Joseph Clifton Smith, age 55, has been on death row half his life after his conviction for beating a man to death in 1997. The issue in Smith's case is what happens when a person has multiple IQ scores that are slightly above 70, which has been widely accepted as a marker of intellectual disability. Smith's 5 IQ tests produced scores ranging from 72 to 78. Smith has been placed in learning disabled classes and dropped out of school after 7th grade, his lawyers said. At the time of the crime, he performed math at a kindergarten level, spelled at a 3rd grade level, and read at a 4th grade level. The Supreme Court has held in cases in 2014 and 2017 that states should consider other evidence of disability in borderline cases because of the margin of error in IQ tests. Alabama appealed to the Supreme Court after lower courts ruled that Smith is intellectually disabled. The justices had previously sent his case back to the Federal Appeals Court in Atlanta, where the judges affirmed that they had taken a holistic approach to Smith's case, seemingly in line with the High Court ruling. But the justices said in June they would take a new look at the case. Alabama Attorney General Steve Marshall said Smith hasn't met his burden of showing an IQ of 70 or below, and the state wrote in its brief that the discussion of a holistic approach is an unjustified expansion of the Supreme Court rulings. President Donald Trump and 20 states are supporting Alabama in the case. Smith did not meet his burden of proving his IQ was likely 70 or below, Solicitor General D. John Sauer wrote on behalf of the Republican administration. Smith's lawyers argue the courts followed the law in conducting a holistic assessment of all relevant evidence in a case with borderline IQ scores. Alabama law defines intellectual disability as an IQ of 70 or below, along with significant or substantial deficits in adaptive behavior and the onset of those issues before the age of 18. That's what we know for now. Reporting from the PEP Radio Newsroom, I'm David Moore.